Hi, everyone. Welcome back to No Offense. I'm Erin, and I'm here with my co-host, attorney Daniel Reilly.
Hi, everyone. Good to be back. Today, we're tackling a topic that confuses a lot of people, the Clerk-Magistrate's hearing. If you've gotten a notice to appear for one, you might be wondering what it means, whether you're in serious trouble, or if you need a lawyer like me.
It sounds really formal and a little scary, but it's actually one of the most important steps in the Massachusetts criminal process. And in some cases, this kind of blows my mind, it's one of your only chances to actually stop charges before they even hit your record.
Exactly, Erin. So in this episode, we'll break down what a clerk's hearing is, how it works, and what to expect if you're called in for one.
All right, let's get into it. So can you just give me a broad level overview of what a clerk's hearing is, the purpose it serves, and kind of the general definition?
Sure. So a clerk's hearing is part of the legal process in the criminal system where there is an application for a criminal complaint filed. Either a civilian or a police officer has gone down to the clerk's office, filled out some paperwork saying, you've done something wrong. We want you charged with a crime. And in that case, the clerk will send out a summons to you saying, come to court so we can figure this out and whether or not a crime might have occurred. So that's the clerk's role, and that's the purpose of a clerk-magistrate's hearing. We're going to weed out some of these cases that don't need to go in front of a judge, but we're also going to make sure that we find out whether or not there's probable cause to issue a charge. And that just means, does the clerk believe they've heard more than enough, 51% or more, that a crime might have occurred? And in that case, they're going to move that case along up the chain to the judge to deal with a criminal matter. And if they don't, then that's going to be one less case that crowds the Massachusetts dockets.
Got it. So you've gotten your summons in the mail. What are your next steps?
Right. So summons is something that comes in the mail. It's just a piece of paper, but it does carry the weight and force of a court order, so you do not want to ignore it. If you do ignore it, there is a chance that the clerk proceeds without you and just issues the charge. And at that point, the next piece of paper you get in the mail is going to be for an arraignment or a knock on your door with a warrant.
Doesn't sound perfect.
That's not good. So take it seriously. Make sure you show up. But yeah, you get that piece of paper. It tells you where to go, where to be, when to be, and you show up. And there's going to be a bunch of other people there too with the same kind of issue as you. They've got this summons in the mail. They have a clerk's hearing. They might not know what exactly to expect or what's going on, but they're there. And so what you do is you check in at the clerk's office, let them know you're there for the hearing, and then you're going to wait with all these other people. And eventually there's a list of names that starts getting called. And they'll get to your name. And then a court officer will bring you into a room. It's not always a courtroom. In fact, most of the time it's kind of a conference room that they've set aside just for these types of hearings. And in that room will be either the civilian who filed the application for criminal complaint against you or a police officer. There'll be the clerk-magistrate who is going to hear from both sides and make the decision ultimately. And then you and hopefully your lawyer. Once you're in there, the clerk is going to swear everyone in that intends to testify, and they're going to hear from the parties.
Do you need to prepare anything? Do you need to bring witnesses? Do you need to bring statements? Just yourself?
That's a great question. So you can expect that at least the party who's filed the application, whether that's a civilian or a police officer, will have something that they have brought in support of their claim that you committed a crime. For the police, it's often a police report. And, you may be in there saying, I don't know this officer. I've never seen them before in my life. But that doesn't mean that you're, this is all a big mistake and you're going to walk out of it just shaking your head about wasting your time. Often a department will send one officer to handle all the clerk-magistrate's hearing for a given day. Okay, so it might mean that it's somebody else that you did interact with. That officer that's there in the room will have their report, and they'll want to read that into the record for the clerk and ask them to charge you based on that. As far as your own preparation, yeah, sometimes it's important to have a witness who can come in and give a statement, or to have, videos or documents. It's not the same as a trial in front of a judge. There aren't the same rules of evidence. You're not going to be given an opportunity to present, multiple witnesses worth of testimony and reams of documents or things like that. I have had clients that have a short video or have a witness who says a couple, brief statements. But for the most part, a lot of people go in there just kind of with their recollection of what did or didn't happen and a desire to convey that to the clerk.
Okay. So, what can happen at a clerk-magistrate's hearing as far as outcomes?
So after the clerk hears from both parties, they can do one of three things. The best for you, if you're the person that's, had this filed against you, is that they find no probable cause, meaning they didn't hear enough to think that a crime might have occurred. In which case they're going to say no probable cause, on your way. And it's done, it's over, you celebrate, it's a win for you, and you go on with your life. So then there's this intermediary step where the clerk can say, I've heard enough where I think I might consider issuing this charge, but I also heard some things that give me some pause. And I also heard some good things about you and your situation. And, in light of that, I think I'm going to be willing to give you some leeway. I'm going to give you a second chance. And what they do is say, okay, for the next 6 months, 12 months, what have you, as long as you stay out of trouble, and in some cases, if you do, X, Y, and Z as a condition, I will keep this case open. And at the conclusion of that period, if I haven't seen your name come across my desk again, if you've stayed out of trouble and done what I've asked, the case is over. So just like finding of no probable cause, no harm, no foul, you do your little happy dance, case is over, you move on with your life.
You said they take everything into consideration, including they may have heard some good things about you. So are you saying that unlike in a trial, you can present good character evidence?
Yeah, so actually, again, you're not in front of a judge. It's not a trial, and the same rules of evidence that would apply there don't apply in the clerk-magistrate's hearing. There's a real opportunity to present things about yourself or your situation that a clerk might look favorably on and give you context for them to make this decision as to whether or not to charge you. And so, yeah, you can present essentially character evidence that wouldn't otherwise be available to you later on if the charge does issue.
Interesting. Okay, so I think I can guess what the last outcome is.
Yeah, I think that one's pretty clear. They find probable cause and a charge is going to issue. And in that case, the clerk turns to you and says, all right, I'm issuing the charge. You're going to have a criminal case. Let's pick an arraignment date for you to go in front of the judge and start this formal procedure that is the criminal case in Massachusetts.
Are you arrested then? Can the clerk impose a sentence? Can you just go into that a little bit?
I've never seen anyone be arrested just because there was a finding of probable cause in a clerk's hearing. The fact that you showed up pursuant to that summons is a good indication that you're going to show up at that arraignment date and start that case at that point. So you're not likely to be arrested. The clerk isn't actually deciding whether or not you're guilty of anything. Again, probable cause is a much lower standard than proof beyond a reasonable doubt, but the standard that's required to convict somebody. And so that's not happening at this point. This is just a kind of step in the process moving you toward that criminal case that begins with the arraignment. So the clerk isn't going to impose anything. The clerk isn't finding you guilty of anything. They're just saying, you know what, I've heard enough to think a crime might have occurred, and we're going to let a judge and or jury decide whether or not that's the case.
And am I correct when I say that would be the only outcome that would for sure leave a mark on your record?
Yeah, so their record really starts once you're arraigned. The good thing about a clerk-magistrate's hearing is it's a great opportunity to avoid all that. If you can get this case disposed of prior to arraignment, then you walk away with no record whatsoever.
So it sounds actually relatively simple. You go in there, listen to what the police have to say or the citizen, and then you have your story and somebody says, yeah, I think a crime was committed, or no, I don't think it was committed. Is this something you need an attorney for, or is that something you would save for an actual trial?
So it is straightforward. I'll give you that. But
maybe you're just good at explaining it.
Maybe. I hope so. But I don't think you want to go into this without an attorney. Obviously, for the vast, vast majority of people, this is not what you do day in and day out. In all likelihood, you haven't been in a clerk-magistrate's hearing before. I do it all the time. I've done it many, many times. I know what it's all about. I know how to play the game. I know that, it's a little bit of science and a little bit of art. You probably just don't have the benefit of experience. And you don't want to make a mistake when so much can be on the line. The other really, really important piece of it is that as your attorney, I can speak on your behalf. I can question the officer on your behalf, and you don't ever have to say a word. You don't have to ever say anything given your Fifth Amendment rights, but it's pretty hard to go into a clerk's hearing and get your side of the story across if you're remaining silent. I can do that for you. I can give that background information about you that we talked about. I can give factual information that you want presented to hopefully convince the clerk not to issue the charge against you. And so that is a huge benefit to having an attorney for a clerk-magistrate's hearing.
So are things that you say during the hearing, can they be brought back and used against you at a later date if there is a finding of probable cause?
Yeah, absolutely. Again, you are sworn in and you're under oath. And so anything you say at that hearing is not only going to be recorded and potentially available to prosecutors if the case were to move forward, but you're locked into those statements now, and they can be used against you. And obviously, that could really make things difficult down the line if you end up at a trial. Whereas if you have an attorney who's advocating on your behalf, you haven't made any statements, and you've been protected by that attorney from potentially saying something that could really haunt you later on.
Okay. So an attorney brings the benefit of protection and a know-how of the game that's being played. But do you meet with your clients ahead of time and come up with a plan? Like, okay, this is what you're saying. You tell me that this place has cameras. Let's get that. We'll present that. And you can come up with a game plan?
Yeah, absolutely. I mean, whenever I represent someone at a clerk's hearing, we always meet ahead of time to go over exactly what to expect and what your defenses might be, whether or not it makes sense to even bring any of this stuff up, what to hold back, because again, if you're going to go to trial later on, you don't want to be giving away everything right at the outset. So a really good experienced attorney knows what to present, what to hold back, and what to do on your behalf.
Okay. This is actually really cool. Like, there's sort of this exit ramp off of the highway to a trial where potentially you can make your case and someone will just say, oh, well, all right, stay out of trouble, kid. And I'll see you back in 6 months. And if you're out of trouble, no big deal. That's awesome.
It's
Love
a huge
that.
opportunity to really save yourself a lot of trouble down the line.
Well, if you liked what you heard today, please do us a solid and rate and review this podcast wherever you listen and share it with anyone you think needs to hear what we have to say. Maybe, I don't know, someone who received a summons for a clerk-magistrate hearing. We also accept listener-submitted questions across all of our socials. And don't forget to follow us for more legal insights on Instagram and X. Our handle is @DanielReillyLaw, and you can find that in the show notes.
And as the resident lawyer here on No Offense, I'd like to take this opportunity to remind you that yes, I am an attorney, but no, I'm not your attorney, and the statements or commentary in this podcast are for informational or educational purposes only. They are not legal advice. However, if you would like to discuss a case, you can shoot me a message on my website or DM me on any of the socials, and we can set up a time to have a conversation. That conversation would in fact be protected by attorney-client privilege, even if you don't end up hiring my firm.
We'll be back next week with more real talk about your rights and the criminal justice system. See you then. Bye.
All right.